Hello, and welcome to the Native Craft Artist Readiness Program, a capacity building program designed to provide Native craft artists with training, resources, mentorship, and financial support towards building sustainable art practices. The program is managed by the Association of Tribal Archives, Libraries, and Museums in partnership with the Craft Emergency Relief Fund. The program is funded by the Wingate Foundation with additional support provided by the Ford Foundation, National Folklife Network, and Nest Makers United. My name is Jess Cordes, and I am the Director of Grants and Special Projects at the Association of Tribal Archives, Libraries, and Museums. This workshop is on some of the legal protections available to artists. We at ATOM are delighted to welcome our speakers from the United States Copyright Office and from the University of Illinois, Urbana-Champaign. I am pleased to introduce Nancy Weiss from the Copyright Office, who will introduce the other speakers and provide the framing of our program today. Nancy's scholarship focuses on the intersection of law and cultural activity, and she has held general counsel and other high-level positions in several federal agencies, as well as practice law and other settings. Thank you for being here, Nancy, Miriam, and Sarah.
Thank you so much, Jess, and good afternoon, everyone. And thank you to the Association of Tribal Archives, Libraries, and Museums for inviting us to present as part of this Native Craft Artist Readiness Program. So we're really honored to be with you here today and discuss copyright tools that help promote sustainable art practices. Two of us are joining from the Copyright Office. Miriam Lord is Associate Register of Copyrights and Director of Public Information and Education. She leads a team that provides authoritative information about copyright law to the public, develops education and outreach programs like this webinar, and responds to public inquiries about office policies and practices. She is an expert copyright attorney and one of 4 legal advisors to the Register of Copyrights and director of the U.S. Copyright Office. And I will just say on a personal note, she's amazing. And she also previously held positions as the director of the Philadelphia Volunteers for the Arts, as well as at the United States Patent and Trademark Office, where she also led training programs. And I'm here, I serve as the 5th Kamenstein Scholar in Residence at the Copyright Office. Sarah Benson is the Copyright Librarian and Associate Professor at the University of Illinois Urbana-Champaign Library. Her research focuses on the socio-political implications of copyright in the United States and abroad. So today, our objective is to roll up our sleeves and during this webinar, introduce the Copyright Office, review basic concepts under copyright law for craft artisans, specifically what is copyrightable and what is not, how to register your work, and what you can do if you see something that appears to be infringing, including online. Professor Benson will then work through a few examples to help you identify the copyrightable elements of works of visual arts, including jewelry and useful articles, and what to do when it appears that someone might be engaging in infringing activity. We hope that you'll view the U.S. Copyright Office as a resource, as well as gain additional insight into the kinds of support available through libraries and copyright librarians. While the presentation will focus on the U.S. Copyright Act, the areas that we'll be discussing may also involve compliance with tribal laws and protocols. Our goal today and always is to provide tools and information to help you make informed copyright-related decisions when participating in the creation and use of works. So with that, I'll introduce Associate Register Miriam Lord to get us started. Thanks.
Well, thank you so much, Nancy, and thank you to all of you and to Sarah and to one of my attorney advisors, Laura, who's also on to help prepare the presentation and for having us. It's really an honor. Like Nancy was saying before I get started, I just wanted to say that working directly with artists and artisans is one of my favorite things. I have a creative background myself, and many of the people at the Copyright Office do, and we all feel really strongly that it's really important to understand where you are in the copyright system and how to both access it as a creator and also as a user of other people's creative works. So it's one of my favorite things to do is to work with people who are looking to understand this and to answer any questions. So thanks for having us. All right, I'm going to tell you a little bit about the Copyright Office. Then we're going to talk a little bit about the law, and then we'll go from there. So the Copyright Office is a part of the legislative branch of the federal government. We're in the Library of Congress. So on the left there, you can see the Jefferson Building of the Library of Congress. And on the right, that's the Madison Building. That's where we're sitting right now, some of us. We have been part of this branch of government since the start of the Copyright Office, and we're the main agency charged with administering the U.S. Copyright Act. So it's everything that belongs in this large volume here, the whole copyright law. Copyright's the area of law that provides legal protection for a lot of different forms of creative expression. Our copyright laws and policies come from the U.S. Constitution, which seeks to promote the progress of science and the useful arts by securing certain exclusive rights to original works of authorship. So when we talk about the Copyright Office administering that, it's a big statement. It has a lot of roles involved. So let's look at the ways that we do that. Next slide, please. So we administer the provision of copyright law for the benefit of both the copyright owners and copyright users. Our mission statement here is to promote creativity and free expression, and by providing impartial expert advice on copyright policy for the benefit of all. So we're advising and also administering the law. So first, we make and maintain records that provide details on copyright ownership. This is subject to research, which includes registration records, but also recorded documents about transfers of ownership and licenses. So we generate and sustain a public record of American creativity and achievement in terms of ownership records. We also provide critical law and policy services, this analysis and reporting on important copyright matters, and we are the principal advisor to Congress on national and international copyright issues. To distinguish, the U.S. Patent and Trademark Office advises the administration to the president through the Secretary of Commerce on intellectual property and patents and trademarks. So last but not least, we provide authoritative copyright information to the public, like Nancy was saying, by answering questions, doing educational programming. So we will talk about some of these resources, and we maintain and update and create these materials, often in response to demand from the public. So we're always happy to hear your feedback. Next. All right, so getting into it, what is copyright protection? So the overarching goal of copyright is set out in the Constitution, which is intended to promote the progress of science or the useful arts, or to promote culture and knowledge. The law gives authors or creators certain exclusive rights to benefit from their works for a limited time, which under the current law right now is usually their whole life plus another 70 years. So unless authors grant permission, no other person or entity can use their works in ways that would violate the exclusive rights that copyright grants. So if someone uses your copyrighted work without your permission, which is what we call infringing, you can make them stop production and perhaps pay you for the damages they've done. You can also make money by giving rights to someone, either temporarily through a license or permanently through an assignment, in the same way that you would manage personal property or real estate. Copyright law is found in Title 17 of the United States Code, known as the Copyright Act. The law itself states that copyright protects original works of authorship fixed in a tangible medium of expression. So what does this mean? It means that we first must have a work of authorship, and that work must be fixed and original in order to be protected by copyright. That's a subject matter copyright protects. It's different than what other forms of IP protect, and it's relevant to our conversation today. So fixed basically means expression has to be written, recorded, or otherwise captured in a copy. It must be sufficiently permanent or stable to be communicated or perceived for more than just a transitory duration. So it has to be written down or sculpted or recorded or something like that. It can't just be an idea. It has to be the expression of that idea. The originality requirement has two components. The first is independent creation, and the second is sufficient creativity. Independent creation means you've independently created it, meaning that you didn't copy it from somebody else. In theory, two different people could create two original, independently created works at the same time that are very similar or the same. And that's okay, as long as they're just by chance and it's not a result of the copy. the creativity involved requires that the work contain at least a small amount of creative expression. It doesn't have to be the first of anything. It just has to have enough human authorship and creative expression. Next. Thank you. Okay, so we have works that are eligible for copyright, and then we have things that are not. And this is part of what we're going to be learning today, which is just thinking about the work that you create and if it fits in these categories. And then that will help you understand, is this a part of what we would call an intellectual property portfolio for you to manage in terms of your business? I really appreciated how your former speaker was talking about thinking about your business and thinking about ways to manage your business that fit with the way that you operate. And that's an important thing to do here, is just how to think about your work in a way that makes sense for you. And this information is just intended to help you think. Nancy, I'll take this slide, and then if you want to take over the next couple, that's
Sure.
great. So what kinds of works are eligible? Well, we've got, go back, please, thanks. Literary works, so things like books, musical works, think about the sheet music, like a musical composition. This is the song underneath the recording of the song. Dramatic works, we have pantomimes and choreography, pictures, graphics, and sculptural works, motion pictures, anything audiovisual, sound recordings, and architectural works. This is what the statute itself says that is allowed to be in here. So whenever the Copyright Office is reviewing an application for copyright registration, that's one of the first steps, is just to pick the type of work that it is and then do the analysis from there. What you won't find here is things like, inventions or secret recipes or things like that. Those are other areas of IP that protect those. So I'll stop there and turn it back over to Nancy.
Thanks, Miriam. So when putting together today's presentation, we really wanted to focus on what you're doing. And we are going to be talking about visual artworks. Visual artworks can take a lot of different forms. They can be paintings or sculptures, photographs, prints. They can also be works of artistic craftsmanship, such as ornamental jewelry designs. Here's a picture of our former poet laureate, Joy Harjo, wearing beaded earrings. Or visual artworks can be applied art, which we're going to delve into a little later in the presentation. Next slide. But let's start with the basics of copyright. Is it copyrightable? As a general rule, if your work is original, that is, you didn't copy it from someone else, you can claim copyright. We're going to start with a print by artist Woody Crumbo, which was registered with the U.S. Copyright Office. Crumbo, of the Citizen Potawatomi Nation, was an artist, educator, flautist, and museum professional. This silkscreen is representative of his signature style. Let's talk about why this is copyrightable, building on what Miriam was talking about. First, it's a work of authorship, which means it was created by the artist. Second, it's fixed. As a reminder, for copyright protection, expression must be written, recorded, or put into a tangible means of expression. Here, it is printed on to paper. The print is also original. It was independently created by Crumbo and has sufficient creativity. Look at all of the artistic details and selections he made in developing that picture. So I'm going to bring it back over to Miriam. Next slide.
Thank you. Okay, so like we talked about before, not everything is copyrightable, and that might include other parts of your lives, other parts of your businesses, as well as certain parts of creative works that you might have. Words and short phrases are not copyrightable. Familiar symbols and designs, typeface, lettering, certain basic shapes, variations of coloring, and that's all that's been added. Things like tape measures or blank forms, these are not considered copyrightable in general. This is just some examples, but one example that we get a lot here is a confusion between the concepts of copyright and trademark when we're talking about brand recognition. So words might be copyrightable if there are many, many words and this is a literary work, but they wouldn't be copyrightable if it's just a title or maybe a brand name or something. So that's an example there. Copyright protects originality. So artistic statements, not pure craftsmanship, no matter how beautifully stitched, carved, or woven. So it's intended to protect the original expressions that you are putting into a fixed tangible medium. Next. Okay, so we have a resource that's really helpful to know about. It's pretty dense, so if you're going to get into it, just settle into the best time of your day. It's a good time block for getting deep into something. But it's called the Compendium of U.S. Copyright Office Practices. This is available for free. All the resources are free, of course, on our Copyright Office website, copyright.gov. And it breaks down how the law works, how this statute affects how we look at copyright registration. And it'll take concepts out and then break them down into really what you need to know about something. So there are parts of the compendium that we'll talk about a little bit today. Just tips for artists you might find useful about the parts of your work that are copyrightable, parts of your work or certain kinds of work that might not be. This is a legal question, so I'll just put a plug in here that it's helpful to be able to bounce ideas off somebody who has a legal background and a lawyer who can advise you if you're looking for that kind of advice. But we're happy to point you in the right direction to all kinds of educational materials to help you get there. So for example, copyrightable elements of the below here, this is an example, is the use of all kinds of colors. This is certainly copyrightable, although if it's just colors, it's not enough. The way that you select and arrange the elements, that's often copyrightable. And one thing I think is very applicable to this group is decorations. So variations of texture, engraved designs, decorative parts of something, if they have enough originality themselves, can often be copyrightable. That may not be the case for the functional elements of those works, such as a clasp or a fastener, but the decorative part of that could be. Things that are common or symmetrical arrangements, and the way that, maybe individual stones could be faceted. We'll get into this later, but this comes up a lot in terms of craft and apparel and jewelry, just distinguishing what's creative and from what's functional and what's not copyrightable is something that'll be relevant to you. Next slide. Okay, so we'll come back to that later because obviously it's a hot topic for you, but we'll move past subject matter and get into what does it mean to own a copyright. And Nancy, just interrupt me anytime, jump in. But owning a copyright means you have the exclusive rights in your work. So that means you have a number of enumerated rights. We call these a bundle. It's like a bundle of sticks, a bundle of rights. When you have a copyright, it means you have the right to make copies, to prepare derivative works, to distribute to the public, to publicly perform it, and publicly display it, depending on what it is. No one else can do that without your permission. And so that bundle of rights is important to understand. I'll also take just a minute to explain, although we'll get into this later, that you own something the minute that it's been fixed in a tangible medium if it's original enough. There's significant benefits to registering it with the Copyright Office, and we have lots of information to help you understand how that works. But it is already yours. You don't need to come to the government and get something. If you want to enforce it, if you want to make the full use out of it as a business, then you do come to us and register it. We'll talk about that. So these are the rights that you have. You can engage in any of these rights as a part of your business. You'll often hear about this in entertainment and literary and fashion businesses, et cetera, because people will divide up a territory or of the right that they're talking about, like here are the film rights, or here we're going to sell to this country specifically or to this part of the United States. That's up to you. You can basically take the right you have and decide how you want to use it. Do you want to use it? Who's allowed to work with you to license or to move from there, which is a good segue into the next slide. Thank you. Licenses. What is a license? It is the way that you express permission. As you, the copyright owner, express permission to someone else to engage in one or more of those exclusive rights. You can limit by geography, by time, format, or activity. This has to do with what you do with what you own. I think the best way to think about licenses is to think of copyrights just like any other kind of property, and just thinking about how you would rent something versus selling it. That's sort of the difference between a license and an exclusive and a non-exclusive license or sale. So an exclusive license has certain requirements. Again, this is an area where it's helpful to get a law clinic or a lawyer to help you, although there are plenty of places to start in terms of what the terms are, what the work is, what has to be in writing. Like an exclusive license has to be in writing. You have to sign it. It provides that no one else can engage in that, only the owner, and it can be a transfer of the right. A non-exclusive license means that, yes, this other person can do something with your work, but other people can too. You're allowed to let many different people do it. An exclusive license is usually more expensive because it's your only shot, whereas a non-exclusive license, you're giving lots of different people an option to sort of act on your behalf. So that can be in writing or given orally. It can be that they can engage in whatever activity you've allowed them to, but so can anyone else with your permission. Next. Okay. So like I said, if you have taken a photograph today or created one of your works, to the extent to which it's eligible for copyright, it's already protected. There's no formalities required. The United States law has changed over time as norms have changed and as we joined some international treaties, but it did used to be the case that you had to register in order to have rights. So you might still hear this. And the law changed effective in 1978. So it's been some time. This is the law. It's been the law for some time. When you create something, it's yours to the extent that it's protectable. But there's benefits of registration with the office, and I'll talk about those. First of all, it puts people on notice that it's yours. So this becomes, it becomes easier to handle situations where your work is being used without your permission because you've already registered with us. And so there is a record that says this is the work title, this is you, this is who you contact in case you want to license it or in case you want to do something with it. And it puts them on notice that if you do want to enforce it, it's one of the requirements. So before you go into court or before you file with a new small claims court that we have called the CCB, that's a step that you do have to take. The earlier you do that, the more notice you put people on, which means the more the bigger the remedies are for you. So it's just more advantageous to do it sooner. So it's a part of your business strategy in terms of what you want to protect. And that's something we can talk about in a bit, but it's a good thing to think about when you're thinking about yourself as an entrepreneur or as a business. Next. Okay, so usually this process in terms of filing a registration is something that you can do yourself. You can certainly work with an attorney to do this as well. You can work with a clinic, but I'm just here to tell you it's fairly straightforward. It is fairly inexpensive. We recommend that if you have access to submitting online, you do that. It's easier, it is cheaper, it is faster. Typically, if you've given us everything you're supposed to when you submit it, which is a registration application, which asks you questions like, what is the work? Who are you? Some information about what the work is, what kind of work it is. And you provide us a copy of it and you pay the fee. We're talking about several weeks or maybe a month or two max. It can take longer than that if it's really complicated or if you're submitting something where you're trying to draw the line between what's copyrightable or not. But yeah, that's the process. We have a public information office I'll talk about later that reports to me that takes a lot of calls, and you should never hesitate to just pick up the phone and say, I have some questions, and point me in the right direction. We're happy to do that. Next. One of our resources, and thanks for adding this, Nancy, we have a new resource as of yesterday, is we have the law, of course. All this is available on the website, free. We have the law, we have the compendium. We have something called circulars. These are plain language versions of those documents that just talk to you like I'm talking to you now about what to expect about the law. They're designed to be friendly but factual. But we have something new. which is this copyright registration toolkit. It's a highly visual, we're talking about visual learning and a little bit earlier. It's a highly visual way of understanding copyright law, understanding the office, understanding how you process a registration and what to expect. So we just put that out, and we would be delighted if you checked it out and gave us your feedback, not only as somebody who might be using that document, but also as an artist. Next. All right. So say you are in a situation where someone uses your work without permission. As the Copyright Office, we're not the ones that take action on your behalf. You take action on your behalf about enforcing your rights, but how do you do that? So you have a number of options. One of them is you have a registration, you file a lawsuit in federal court. That federal court can stop the sale or importation of infringing goods. The statute allows for money damages. You will have to have already registered. If you registered within 3 months of the publication date or when the infringement occurs, there's a legal presumption your copyright is valid. Ordinarily, you have to prove actual damages to recover in a copyright lawsuit, which is a lot of work to determine exactly how much money you should be owed. But if the work was registered before the infringement, you can recover statutory damages and possibly attorney's fees without providing damages. So that can be hugely helpful for you because it means that the other side is paying your lawyers and paying you money in a way that's easier for you. So that can be very powerful. That is an option. There are a lot of other opportunities for enforcing your work. Some of them are a little bit lower key, like notice and takedown, which we'll get to in a little while, as well as filing with our Copyright Claims Board for certain remedies at the Copyright Office. But the important thing to take away from this is just, know what you own and then know what you can do about it if you have the unfortunate circumstance where you think it's possible somebody else might be ripping you off, basically. Next. Okay, so I said notice and takedown. What does that mean? We can go into a whole law school rabbit hole here, but we're not going to. But there's a law called the Digital Millennium Copyright Act as part of the copyright laws. And it's designed to address copyright infringement in the digital environment. And what it means at a really high level is that online service providers have to provide you an opportunity to say, hey, that is mine, and to file a form that says, please take it down, it belongs to me. I have the public display or sale or distribution rights for that. Having a copyright registration is generally helpful or required in those circumstances, and same for trademarks, which you'll hear about another time. And so there's a whole process for this. We have some resources for this to get into, but it allows you to ask an online service provider to take something down without you having to go to court. Now, there is the opportunity for the other side to say, oh no, we're using this educationally, or there's some reason that this is ours instead, and then maybe you do have to take further steps from there. But it's just kind of like a first option. It would be similar to sending a cease and desist letter or otherwise just saying, stop doing that. So that's a new part of the law. It's not super new, but it's new as about 20 years ago, 25 years ago. And it is a tool that you'll be familiar with from your interactions on the internet. Next. It's a little more detailed than you probably need, but what happens is first you go on notice and you say, all right, it's time to take this down. Usually the platform expeditiously takes it down, notifies you, notifies the other party that put it up, and then they can either counter notice or respond and they disagree. And then if they disagree and it turns out that you don't have a valid claim, they can restore the access and then you can take it to court from there. So, essentially, I don't think it's important to go into this too far in detail, but the point is just this is a procedure that didn't exist before. As a part of the internet and how the internet has developed, has helped the law to develop, there are options for you as you navigate that, or as you're working and you put up your own work and someone else thinks it's theirs. There's a framework to navigate. I do suggest if you get involved with that you talk to a lawyer if you can, because it's important to know kind of how strong they think your case is before you decide kind of how and where to fight it. Next. Okay, something that I do recommend that you try because it is new is the Copyright Claims Board. So the Copyright Claims Board is a brand new remedy for copyright infringement and a couple other related claims that is a small claims court. So think about your municipal court um, within a jurisdiction where you're bringing maybe contract or fraud claims, just little things where you're not going to federal court. This is an option for copyright office, for copyright claims, and it's within the Copyright Office. It's all virtual. There's no traveling to Washington to do this. It's inexpensive. It's designed to be more streamlined and quicker and less expensive than federal court. And essentially what happens is that if your work is used without your permission, this is something you can look into. You will have to go through some normal litigation steps of serving process and making sure you filled out the paperwork correctly and making the case that you own this. If you haven't registered the work with us beforehand, you'll need to file a registration, and that will have to be processed before the claim can go forward. But this is not a judge or jury in federal court. This is in the legislative branch and within the Copyright Office. And there's 3 copyright claims officers who oversee those. They have a lot of experience with copyright, which is really helpful because they understand how copyright should work, the experiences of people that are in these situations on both sides, because that's their job. So I'll just note in here that there is a registration requirement for enforcement, generally speaking. The difference with the Copyright Claims Board or CCB is that you don't have to have registered it before. You can register at the same time. It's just that it has to make its way through while the matter moves forward. I'll repeat that it's completely virtual. This is important that you're aware there's no travel or anything like that. Now it is voluntary, which means that you have to agree and the other party has to agree too. And if they don't agree, then your options are going to court and doing a takedown if it's online and then going to. Next. Okay. I'll just pause for a second and do a check with Nancy if there's anything you want to get into before we move forward.
And no, I think it's nice to have a breath. And now we're going into that little deeper area that we talked about at the very beginning, on some of the copyright law that applies specifically to crafts. So roll up your sleeves again, give it a little further, and let's jump in.
Great, thank you. So we talked a little bit earlier about useful articles. The parts of your work that are protected by a copyright are the parts that are expressive, the parts that are artistic. So we have to carefully consider the parts of it that have utilitarian functions. So patent law actually protects utilitarianism, like how things work. Copyright protects how things are expressed. These are different. So when we're examining copyright registration, we're looking at what parts have intrinsic utilitarian functions that aren't merely to portray the article, the appearance of the article, or to convey information. So it's a little bit of jargon, but what we're talking about here is basically what's the part that functions? What's the part that is artistic? When those are blended together, it's a harder question. So when we're talking about carpets, glassware, bowls, textile fabrics, articles of clothing, we have to think about this as have a function, and what about this is really the creative part. So I'll move on to the next slide.
And I will say we threw in a ringer when Miriam mentioned tape measure earlier and went along with it. That really was to keep you on your toes. A tape measure is a useful article. So that's one of those categories, or an aspect of a useful article that may not be protected, or, as you're about to hear, could be under certain circumstances.
Right. So we'll get through this slide, and then I'm going to turn you over to Sarah, and we're going to talk a little bit about, working through some examples to understand this. Because for those of you whose work falls into some of these areas, that you're going to be encountering this. It's important to understand. So the design of the article could be considered a pictorial, graphic, or sculptural work, which those are usually protectable. Think about things like a painting or a sculpture or something. If that design incorporates those features, if those features can be identified separately from and are capable of existing independently from the utilitarian aspect. So what this means is we do a separability test. There's a court case that set the standard, relatively recently that gave us a little bit more information. That's how the law works here. We have the statute, this, and then we have the way the courts interpret it, and that's those impact how the law works here. So this case was in 2017. This is a Supreme Court case, and it has two parts. So the first part is, are there any features that can be perceived as 2- or 3-dimensional works of art separate from the useful article? So things like this is like a painting that's on a dinner plate, or an artistic print on wrapping paper, or an artistic pattern woven into a rug, or a carving on the back of a chair. The second part of the test is, would these features qualify as a protectable work, either on their own or fixed in some other form of tangible medium of expression? So like a statuette used as a lamp base in the previous photograph, or a work of art on a t-shirt. Works of artistic craftsmanship are protectable insofar as their form, but not their mechanical or utilitarian aspects are concerned, and they're considered works of original authorship. So we'll get into some examples, but this is a thorny area of copyright that you don't really get into if you're a photographer or a painter or a filmmaker or a writer or something. But if you're a craftsperson, you're going to be in this place a lot. So I'll stop there and turn it back to Nancy to introduce Sarah and get into some detail.
Okay, well, Sarah, over to you to actually work through some of these different kinds of things and also to offer some practical tips.
Yeah, so hi everybody. We're going to do an exercise where we are going to try to look at a particular item and identify which parts of it are utilitarian. And when we say utilitarian, we mean functional, right? So like a chair is functional because I can sit on it. That part of it is not then copyrightable. However, as Miriam was mentioning, if you had creativity in the carving of the back of the chair, for instance, that part of it is creative, and that part of it might be copyrightable. So what we have to do is identify the useful stuff, and then we need to look at the artistic features that can be imagined separately from the useful stuff, right? The back of a chair is still useful. It's holding my back up. But the carving, I can imagine it apart from that, right? I can imagine just this beautiful like image of a carving. And that is the part that maybe is copyrightable. And then we have to ask, of course, lastly, once we've imagined that creative part separately, is it copyrightable, right? Because we said earlier, there are a variety of things that are not copyrightable, such as like simple circles and shapes. So we still have to kind of ask ourselves, even if we imagine it apart, is it, minimally creative? Is it copyrightable? Okay, next slide. So I saw in the earlier part of this presentation, someone was sharing ribbon skirts or ribbon designs. And I think that this is a common, it's a really popular design. And so this is something that I kind of thought, let's break that down. Let's think about that as an example. So let's think about whether a ribbon skirt is copyrightable. So if you look at a skirt, for instance, right? Skirts they are useful, right? We wear them and they cover our legs. They keep us warm, right? We have zippers or some way to attach it, right? So clothing in general, the useful part of clothing is the design of a clothing item generally is considered useful or utilitarian. But then we have designs on the fabric. We either have designs on the fabric itself, like a tartan pattern, right? If you're thinking of plaid, general tartan fabric is not usually copyrightable, not creative enough because it's just too standard. But there have been examples of tartan that is, let's say, bigger, wider, variable in color. So that might be creative enough to have a copyright. In terms of these ribbon skirts, we can imagine the ribbons or the pattern of the ribbons apart from the skirt. Now, if the ribbons actually make up the skirt, then they would be functional, right? Like if you had no fabric under them and they're just tied together, that would probably just be a functional thing. But if you have it, you can see on this photo, they're kind of put onto the fabric. So then it depends. The answer is, okay, we can imagine the ribbon design apart from the skirt. And then the question is it copyrightable? And that is where it gets complicated, right? The answer is it depends on how creative it is, right? On the standard design that we have on the left here, where they are all in a row, kind of lined up, maybe it's not enough to be copyrightable because we have kind of a standard pattern. But I've seen ribbon skirt patterns that are very, very designed, right? That have zigzags and have crossovers, have images in between them stitched on and different things, right? So it really matters kind of the individual piece of work. Next slide. So another example of a useful article is a belt buckle, right? A belt buckle is useful. Why? It keeps your belt together, right? That's the useful part of it. And so you then again have to imagine the creative parts separate from the useful part. And here, for instance, the fastener part of the belt buckle, that would be too much of the useful part. But if you imagine, for instance, some of these birds on here, you can see that they're pretty creative, right? And so you might be able to protect those parts of the design that are creative. And we were even talking about fasteners for, say, a stone earlier as not generally being copyrightable. But here, the fastener for the stone or part of it is the shape of a leaf. So that might be creative enough that it would merit some protection. So that again, you know, these would be the cases where if you sent this into the Copyright Office and tried to register the work, the Copyright Office would also have to go through this analysis of is it separable from the useful design, and it might take a little longer for them to process the registration, right? If it's a photograph that you took that you can say, I took this photograph, then that's a little easier for them to process because they're also analyzing, is this copyrightable? Next slide. So here is an example of that beautiful painting that was then put on paper, prints. And let's assume this artist, he copyrighted his work. He was, you know, he registered it, right? He automatically has a copyright, but he registered it. And then he started seeing it all over the internet. So he thinks, what can I do in this instance? Okay, so a few things, you know, to take a step back. You don't have to put a copyright notice on your work, right? In order to have a copyright is automatic. You don't have to register it. You don't have to put a copyright notice on it. You own that he owned that painting from the moment he painted it. But it's not a bad idea to put a copyright notice on your work because a lot of people don't know that. A lot of people don't understand. Oftentimes I ask a room full of students, like, how many of you own a copyright? And nobody raises their hand, right? Because they think they have to do something special. And then I say, well, how many of you are writing a paper for a class? Every single person, right? And then the hands go up. I said, well, you all own that. And so putting the copyright notice on the work is a good idea if you want others to know that you own it. It's really easy to do. All you need to do is put the copyright symbol, your name, and the year. So if I owned this, of course I obviously do not, but if I did, I could put, you know, copyright Sarah Benson 2025 in the lower right-hand corner. I have faculty who do that on their syllabi. I have faculty who do that on their PowerPoints if they just want others to be aware who owns that work. So if you find it, let's say on the internet, on someone's website, you know, you might be able to take a couple different actions. We noted the Digital Millennial Copyright Act. There may be a formal procedure where you can, if it's on, say, you know, a website like YouTube or eBay or something, you might be able to actually notify YouTube, notify the provider. But if you see it on, say, a personal website or something of that sort, you can always write to them and let them know this is my work, right? It's, you can just tell them, like, I created this here, you know, here's the date that I created it. I would appreciate you take this down. I'd like to hear back from you within a certain period of time. And that would give you some indication. Some people are willing to remove things, right? That sometimes is all it takes. Other times they're not going to respond to you at all, or not respond to you unless you have legal representation. If they, you know, it just really depends on the person. But I have had good luck with faculty just reaching out to people, right? And just trying to let them know, like, hey, this is mine. I don't appreciate this. And especially if it's a service provider, working through those steps with the Digital Millennial Takedown Act. And of course, you can always contact copyright librarians if there's one near you. I'm happy to talk to people in general. In my role as copyright librarian, I cannot give legal advice, so I can't be your lawyer. I can't give you any legal advice, but what I can do is I can give you information. And we have a lot of information on our websites. We have library guides all about copyright. We have guides all about the Digital Millennial Copyright Act and things of that nature. So there are a lot of things that, you know, of course, the U.S. Copyright Office can also give you a lot of information. So can librarians. When it comes to, you know, actually taking legal action, you know, then you can either hire a lawyer or you can do it on your own, which is called pro se. And, you know, those are some options that you have available to you. All right, next slide. I think I pretty much went through a lot of practical tips already. This was just a placeholder for me to say, you know, copyright librarians are really useful people. I work at a land grant institution, so I serve really the general public. And so if you send me an email, I will get back to you and I will respond to you. Again, can't give legal advice, but I can give a lot of information.
I think, Miriam, if you
Yeah.
would kind of just give us a little bit of context.
Sure, absolutely. We'll be wrapping this up and then doing some questions at the same time. So, as I mentioned at the beginning, copyright is one of several areas of intellectual property. You may have also heard about these, and you probably also are already engaged in these, and you'll have some additional programming about it. But there's copyright. We discussed that today. That's the first column here. It protects original expression. It's like song lyrics, or of course, something like a painting, or non-functional elements or separable functional elements that have an artistic value in something like a craft. What you can do if you own it is engage reproduction, distribute, public display. Do you need us to secure the right? No, but to enforce it, yes, in your term of protection. We have the same breakdown for patents and for trademarks here. Patents are very different. They don't protect how things look and feel. Utility patents don't protect that. They protect the utility of something. So new and useful inventions that are sort of the first of their kind. And there's also design and plan patents to cover those things. So design patents are something that is helpful to look into in the field that you're in. An example of his design patent is something like the original Coca-Cola bottle. It protects sort of the shape of it, the way it works, the way liquid flows through it, but also how you experience it. The utility patent generally is about 20 years from the filing date. So it's a very different term than your whole life plus another 70 years. The idea is you share with the public how you did this new thing so that scientifically they can build on that and create new innovations in the future. So just a different incentive structure, but it's in the same part of the Constitution together about the progress of science and culture and knowledge. Trademarks, completely different, always very relevant for people in the crafts and arts areas, because if you're building a business, this is your brand. This is your name brand. This is your logo. This is your tagline. This is a source identifier for people who are doing business with you. You want them to know your trademark so that they can accept no imitation. You want them coming to you because they can expect quality, and this is how they know. So this would be like a word or a symbol. You do it by class of goods. So somebody using a name for an airline Delta would be very different than someone using Delta for insurance or faucets or something. And the term is indefinite as long as you keep using it. This is something that you can own. You don't need the government to secure the right. Patents you do. You don't own it until you get a patent. But just like with copyrights, trademarks at the federal registration level do come with additional benefits. So if you put people on notice through registration, then going to enforce it or doing a notice and takedown is going to be a lot easier. And sometimes that's the only way in the door. Thanks.
Yeah, thank you. You know, and next slide. In addition to these different forms of intellectual property, we wanted to mention that Indian arts and crafts products are protected by the Indian Arts and Crafts Act. This prohibits misrepresentation in the marketing of Indian crafts products within the United States. We provided an example of what's protected under the Act. Products sold using a sign claiming Indian jewelry would be a violation if the jewelry was produced by someone other than a member or certified Indian artisan of an Indian tribe. We're actually giving you just a little bit of a taste because we know that on June 18th, you are going to have a presentation by Ken Van Way of the Indian Arts and Crafts Board and Susan Anthony of the U.S. Patent and Trademark Office. So what we've done is communicate with them and try to think about how our presentations could work together. So with that, we're actually going to bring you into our conclusion. And for that, over to the head of Public Information and Education, Miriam.
That is me again. So I'm back and I'm going to tell you a little bit about how to contact us for assistance or for resources. So Copyright Office staff members, we can provide a walkthrough service or registration. So this means that you can call the office, email the office, have an appointment, learn about how to make your way through an application. Now, just like Sarah, I'm not your lawyer. She's not your lawyer. My staff is also not your lawyer. We can't represent you. But what we can do is we can show you, this is the form you're looking for. Here's the educational resources that'll help you fill it out. And the toolkit that we've just put out really walks through some of those. You know, it really tells you what do you need to have with you before you start this process. And if you have questions, who do you call? So you can call us. You know, we have regular business hours, and you can send us an email and we'll pick it up and get back to you. The information on how to contact us is there, but I will just tell you that on copyright.gov, just our website, all of that information is on the bottom of every page. So if you're on there checking out a resource and you decide you want to give us a call, you can certainly do that. In addition, we do have, next please, any number of educational resources. This includes our website, of course, as well as educational webinars and programs that are always free. And lots of little YouTube videos and tutorials, things like that.
Okay. Thank you to Miriam, to Sarah, to Jess, to all of you here today. We're going to actually conclude here. It's really been an honor to join you and participate in this program. So we've recorded the webinar and we've sought to make it evergreen by reviewing several areas of law and applying them to different scenarios. As Miriam and Sarah have described, there are so many resources available to you on your journey. Our goal is expanding your understanding of copyright and help you make decisions when applying copyright law. So for that, this concludes the recorded part of today's webinar.